Litigation in India cannot be understood outside the framework of the Constitution, and the Constitution of India cannot be understood bereft of the independence movement struggle that came behind. So I feel if at all India should have a new constitution which is a better one, that can happen only if and when a second independence movement takes place. And perhaps the conditions for that are slowly emerging. It may not be visible to those who are not in India, but I think for those who are keenly watching what is happening in India, the conditions for that are actually slowly emerging. The Constitution of India in its preamble says, "We the people of India do hereby adopt, enact and give unto ourselves this great Constitution." And Justice K.K. Mathew in one of the Supreme Court judgments points out that the expression "we the people of India" is legal fiction. Because we the people of India never actually voted in order to create the Constituent Assembly. It was only those who had a certain amount of property and a certain amount of education, and if you added all of them together, that would be less than 25% of the population, and it is they who wrote the Constitution. Yet, 15%. Karamat corrects me. Karamat is one of those guys whose understanding of India is better off than many Indians. And that is our great asset of being a South Asian in his company. Less than 15% is what Karamat is telling me. So that is the nature of the electorate that put the Constituent Assembly in place. Yet, even though that may be so, on the one hand, the Indian Parliament certainly represents a much more larger constituency. Because of adult franchise, everybody votes, and so there is the traditional battle between what is contained in the Constitution and what is contained in parliamentary processes. So if Parliament represents a much larger constituency, how can you tell Parliament not to amend the Constitution? After all, it was prepared by a lesser number of people's mandate. But then I think in that context what is important to remember is that the Constituent Assembly was the product of the independence movement. And the independence movement had galvanized literally all sections of the people. And so that is the area in which I think the politics of constitution and legal dimensions must be kept in mind. I'll return to some more related things at a later stage. But now let me get into the public interest litigation aspect of it. Well, in India, we have had, a contestation in relation to the expression public interest litigation. Our brilliant legal academic, Professor Upendra Bakshi, he is the one who coined another expression called social action litigation. And so those who are familiar with this terrain, they very often use both these expressions somewhat interchangeably. Now, so far as PIL is concerned, PIL, it's made a very huge contribution to constitutional jurisprudence. And not only to constitutional jurisprudence, but also to administrative law jurisprudence. Because you are aware that the judicial review of administrative action is a very important area when it comes to questions of implementation, questions of social justice, etc. So, PIL has a lot to do with the interplay of the fundamental rights and the directive principles of state policy. Fundamental rights, as you are aware in most countries of the world, deals primarily with civil and political rights. And directive principles primarily deal with economic, social and cultural rights. So it's good for us to remember right at the very outset in the context of PIL that on the one hand in our constitution you have the equivalent of the International Covenant on Civil and Political Rights. That's in the Fundamental Rights chapter. And on the other hand you have the equivalent of the International Covenant on Economic, Social and Cultural Rights, and that is in the Directive Principles chapter. And in keeping with the international human rights jurisprudence, the assumption has been that civil and political rights can be justiciable. If they are violated, you can go to a court and you can seek a remedy. But when it comes to economic, social and cultural rights, they are not justiciable. You can't expect the court to make them applicable. The courts cannot order for their implementation. That's the broad old jurisprudence. I come to this point later. The Indian judiciary, through its interpretative techniques, through judicial activism, has altered this international human rights quite substantially. And that is by saying that many parts of the directive principles are a direction to the government. The government must act according to the directive principles of state policy, and that is contained in the Constitution. And many of those directive principles must be read into the fundamental rights, and through that mechanism, we now have a human rights jurisprudence in India, which in a sense overtakes human rights jurisprudence in many other parts of the world, including the Western world. So it's not right anymore in India to say that economic, social and cultural rights are not justiciable. That is of course the classical position. But if you look at it through the eyes of the right to life, Article 21, then almost every basic need of a citizen is covered by Article 21. And Article 21 lies in the Fundamental Rights chapter. And as a result of this interpretative technique, please remember, it's a useful thing to say that economic, social and cultural rights are indeed implementable even under certain situations. Now, so far as developments in constitutional law are concerned, the most important aspect of it has been that these developments have happened through judicial interpretation. But when one looks at public interest litigation, there is a tendency to look at the judiciary as if it is playing a very progressive role. You can't deny that the judiciary is playing a progressive role so far as public interest litigation issues are concerned. But I think for people like us from a law background and a social movement background, that would be a superficial understanding. I am of the view that first of all, we must look at what was the historic role of the judiciary. And I do that in relation to India in a very pithy manner. So far as the historic role is concerned, the best way to test what was the thinking of the judiciary in India is to look at it vis-a-vis the right to property. Those of you from India, you may be familiar that Article 19 is a very precious fundamental right in India. There is in 19 A, B, C, D, E and F, there are 6 rights contained in Article 19. It's a kind of article which contains all the freedoms. But when you analyze those freedoms carefully, you find 5 of those freedoms relate to civil liberties. Freedom of conscience, freedom of speech, freedom of religion, freedom of movement, freedom to form an association. So you have 5 freedoms which are concerned with civil liberties. And the 6th freedom is in relation to the ownership, the enjoyment, the disposal of property. Private property was recognized in the Constitution of India in the fundamental right. Why did this happen? Since Colin asked me to refer to the Constitution, here is one window through which I'd like to look at the aspect of what was the role of constitution making in this process. And then I'm reminded of something which is relevant, I think, to us, and that is when the Constituent Assembly met for the first time in India, the political resolution of the Constituent Assembly had to be moved by Pandit Jawaharlal Nehru. And Nehru is addressing the Constituent Assembly, and those of you who are familiar with Nehru's writing and his speeches will know that he is a brilliant speaker, and his writings are also extraordinarily brilliant. It is worth reading glimpses of world history. They are letters which Nehru has written to Indira Gandhi when Indira Gandhi is only 12 years old and Nehru is in prison. And I remember a professor from the Soviet Union by the name of Professor Bondarovsky. He was somebody who used to come to India frequently. He used to tell us that the world's best textbook on world history is Glimpses of World History, and that is the letters that Nehru has written. It's extremely readable letters, and I think most of us will be in agreement with the contents that are in that, from the point of view of understanding, fascism, from the point of view of understanding imperialism, the anti-colonial movements, the national liberation movements, etc. But what I am going to tell you now is something else. That this great man who is so fluent with his language, when he is moving the first political resolution, looks like a shattered man. This is my interpretation. It's based upon the text that I read. And I find him almost apologetic. And if you look at what's the reason for it, he says, you know, a large number of seats in the Constituent Assembly are unoccupied. They are empty. And the reason for that is, by then, the logic of partition has taken over. And therefore, those who were the leaders of Pakistan, they decide not to attend the Constituent Assembly meeting. At that stage, the final decision is not yet taken. And so Nehru is appealing, you know, will you be able to come back into the Constituent Assembly? And I think that's the reason why Nehru is not himself totally. I'm not finding fault with XYZ in this context, but trying to share the context. And then, it's then that he says, at one part of the political resolution, we are not going to use the word socialism in our constitution. And the reason why we will not use the word socialism is because if I use that word, there will be a few dissenting voices in the Constituent Assembly. If you were to put it to vote, the overwhelming majority will support socialism. But we will not use it because at this moment what is very important is that we must achieve unity. And you might be aware that the biggest effort at that point of time is to set up a republic, the Republic of India. And what does the republic mean? The republic would be possible if only if 500 and more than 500 princely states of India were already waiting in the wings and would be quite happy not to become a part of the Republic of India. And the British were equally keen that India should not remain one united subcontinent. And therefore, right from 1930s or even earlier, they had started sowing the seeds of division. First between the Muslims of India and the Hindus of India, and encouraging the communal award, and going towards creating separate representation for the Muslims and for different denominations. So that was the atmosphere. And in that atmosphere, in order to keep a republican spirit alive, I think, there is a compromise insofar as socio-economic rights are concerned. It is therefore my reading that the right to property found its place in the fundamental rights chapter for this reason. And after independence, what was the biggest task that India faced? Yes, zamindari system was more or less successfully abolished. But when it came to the implementation of land reforms, the biggest obstacle to land reforms in India was the Indian judiciary. So today, while we look so progressively at the judiciary in PIL, please don't forget for a moment that when the important time came, had we achieved land reforms at that point of time, the story of India would have been different. But land reforms could not be proceeded with except in the state of Kerala, in the state